among the examined items. My Lord, what this means is that it directly connects the accused to be the user of that knife that killed the infants. My Lord, there was also evidence from the sunglasses of the accused of the DNA of body 39, which belonged to one of the deceased children, Keisha again Roth. My Lord, on the accused's trousers, it was DNA of body 37 of Ignatius Seryange.
What was on the trousers?
DNA of body 37, which body, my Lord, belonged to Ignatius Seryange. My Lord, that evidence and more that we laid on record is sufficient to place the accused at the scene, but also prove his direct participation. We want to add, my Lord, that throughout his defense, the accused never denied causing the death. Of the deceased children. He only claimed that he believed he did not have the intention to cause their death. He claimed that he was distressed between January and March this year, and that his killing of the 4 children on April the 2nd could have had something to do with his alleged distress. My Lord, from the accused's defense, we understand him to be raising a defense of insanity, for which we want to address court.
Nti kukyokulaga oba omuwaabirwa yeyaza omusango guno oba nedda, baleeta obujulizi obw'enjawulo. Obujulizi buno bumuteeka bumusanga we batira abaana, ate ne baleeta obujulizi bulaga nti ye yabatta. Baleeta obujulizi bw'abantu ababiri abaliwo, ye omujulizi ow'omukaaga n'ow'omusanvu, era bagamba nti Omwami Okero bamukwatira mu kifo abaana abo we baafiira. Baleeta obujulizi bw'omujulizi owa 17, era yajja n'agamba nti empale Okero gye yali ayambadde gye baleeta ng'ekizibiti ekyo16 yaliko omusaayi gw'omu ku baana baafa, era omwana oyo omulambo baali baguwadde enamba 37 ate nga gwali mulambo gwa Seruyange. Era ne baleeta obujulizi obulala nga bagamba nti akambe akakozesebwa kaliko endagabutonde ya mwami Okero, nti ekyo kiraga nti mwami Okero ye yakozesa akamba ako. Obujulizi obulala buva ku galubindi ezaali za mwami Okero, bazikebera ne basanga nga zaliko omusaayi gw'omulambo gwe baali bawadde namba 39 nga gwali gwa Keisha. Nti obujulizi obwo n'obulala bumala okulaga nti omwami Okero yali mu kifo ekyo era yaza omusango guno. Nti yali nga yeewozaako ye teyeegaana musango, wabula kye yeegaana kyokka yali agamba nti ye kino teyakigenderera okuvaako okufa kw'abaana abo. N'agamba nti wakati wa mwezi gwa January ne Maachi omwaka guno yali alina obuzibu, yali mwenyamivu, nti ate agamba nti kyandibanga kye kyamuviirako okutta abaana abo ng'ennaku z'omwezi 2 ogwokuna omwaka guno. Nti mu defense ye alabika nga agamba nti yali omutwe gwe tegukola bulungi era kati omuwabi wa gavumenti kyagenda kwogerako.
My Lord, this defense of insanity seeks to do away with the essential ingredient of malice aforethought. And when this defense is raised by any accused person in any criminal trial, my Lord, the starting point is Section 10 of the Penal Code. My Lord, you will allow me to read Section 10 verbatim. It provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved. In other words, my Lord, there is a legal presumption that every living being is sane. And whoever wants to dispute that presumption of sanity, my Lord, bears the burden to prove the contrary. And therefore, my Lord, it is not right that the defense faults prosecution for failing to lead what they termed evidence of his sanity. My Lord, that
without evidence of his insanity.
For failing to lead evidence of his insanity, I beg your pardon, my Lord. Evidence of his insanity. My Lord, that burden is not shouldered by the state. Because as far as the law is concerned, every man is sane.
How about women?
So, my Lord, by man, I actually mean both men and women, every person. Every person. And my Lord, this principle has been exemplified in several authorities. And we have quoted one of Nsabimana Richard, my Lord, versus Uganda on page 8, where our Supreme Court held that every person of age of discretion is, unless the contrary is proved, presumed by law to be sane and to be accountable for his or her actions. That the onus is on the defense, and my Lord, we want to highlight that the burden is on the defense to establish such insanity on the balance of probabilities. In our submissions, my Lord, we highlight other authorities that speak to the same principle. Maybe Evelyn wants to just summarize.
Ekyokugamba nti oba omutwe gwe gwali gukola bulungi, bwe boogera ku kyokugamba nti omutwe gwe gwali tegukola bulungi, kiba kijjako ekyokugamba nti yali agenderedde kye yakola, nti naye oludda lw'omuwaabirwa bwe bagamba nti omuntu ono omutwe gwe gubadde tegukola bulungi, kooti erina okugenda ku mateeka akawayiro ka 10 mu kitabo ky'ebibonerezo, ate nga kigamba nti buli muntu mu mateeka bamutwala nti ategeera bulungi era omutwe gwe gukola bulungi, okuggyako nga baleese obujulizi obulaga nti omutwe gwe tegukola bulungi. Nti kigambirwa nti buli muntu akola bulungi mu mutwe, nti era bw'ogamba nti toli bulungi olina okuleeta obujulizi kukikakasa. Nti ate abaludda olw'omuwaabirwa si batuufu okugamba nti ab'oludda oluwaabi balemererwa okuleeta obujulizi obulaga nti omwami Okello yali omutwe gwe tegukola bulungi. Nti bw'ogamba nti omuntu omutwe tegukola bulungi, oludda oluwaabi terulina kuleeta obujulizi okulaga nti mu butuufu oyo yali takola bulungi mu mutwe, kubanga kusinziira ku mateeka kigambirwa nti buli muntu abeera bamutwala ng'omuntu ategeera bulungi. Nti ate ensonga eno waliwo emisango emirala kkooti ezawaggulu gye zisaze okulaba nga ogwa Nsabimana versus Uganda mu musango gwa Supreme Court, era bagamba nti buli muntu alina emyaka etegeera bamutwala nti omutwe gwe gukola bulungi era asobola kumanya biki byakola n'ebivaamu ng'akoze byakola. Era bagamba nti ab'oludda lw'omuwaabirwa be baleeta ekyokugamba nti omutwe gwe tegukola bulungi, n'olwekyo be balina okuleeta obujulizi okukakasa nti omutwe gwe tegukola bulungi.
My Lord, on page 10 of our submission, we highlight the fact that the defense has failed to prove the accused's claim of insanity for 2 reasons. First, my Lord, the defense laid no evidence to show that on the 2nd of April this year, when these crimes were committed, that the accused was suffering from a disease of mind which deprived him of understanding the nature and consequences of his actions. In fact, my Lord, in his defense, the accused did not say that he did not know his actions. His evidence was that he only believes that his actions on the fateful day could have been influenced by the distress that he claimed to have had between January and March. He does not say that on April 2nd, when he killed the infants, he had any distress of whatever nature. My Lord, the accused did not say so. Besides, my Lord, even his probable effect, even the probable effect was simply his belief and not evidence of fact. My Lord, the presumption of sanity is a very strong presumption, and to rebut it, the defense must do more than merely speculating on the possibility of a likely mental disorder. My Lord, the defense bears the burden to satisfy court on the balance of probabilities, of course, the existence of legal insanity at the precise moment of the crime. My Lord, as opposed to what the defense submitted, where there is any doubt, the law favors criminal culpability. And not the other way around. My Lord, we have cited for you the case of Jumba Joshua versus Uganda on page 10 of our submissions, that among others sets the material considerations that must be proved for the defense of insanity to succeed. We only want to emphasize the first consideration, my Lord, is that the mental condition or state of the accused's mind is assessed as at the time of the offense. My Lord, not yesterday, but today. So it is not sufficient, my Lord, for an accused person to say that I have ever suffered from a disease of mind. That doesn't discharge the burden. My Lord, we want to interest you in a very persuasive authority that we got from the Philippines. My Lord, on page 11, the authority of the people of the Philippines versus Little Pama Y Inandan. Where it was held while quoting, my Lord, the guidelines of their earlier case of people versus Formigonis that that there is a three-way test, my Lord, for the defense of insanity. It's a three-way, my Lord, in a sense that first, insanity must be present at the time of commission of the crime. Second, insanity must be established to have been the primary cause of the criminal act. It must be medically proven. And three, it must be proved, my Lord, that the effect of the insanity is the inability to appreciate the nature and quality or wrongfulness of the act. Inability to appreciate the nature and the quality or wrongfulness of the act. My Lord, that standard has been applied in the Ugandan case of Uganda versus Mwesigwa Ivan, which we also quote on page 11. But the sum total of these this three-way test, my lord, is that mere verbal assertions of previous history of mental illness is insufficient. The requirement is to prove insanity at the time of the offense to the required standard. My lord, we still...
Let's have
okay.
interpretation first.
Nti oludda baloya ba mwami Okero balemereddwa okuleeta ebiraga nti Mr. Okero yali ng'omutwe gwe tugukola bulungi olw'ensonga tebaleeta bujulizi obulaga nti nga 2 Ogwokuna 2026 olwe abaana bano olwe baafiira nti yali alina obulwadde bw'omutwe oba yali tategeera biki bye yali akola. Era mu difensi ye nga yeewozaako teyagamba nti bye yali akola yali tabimanyi wabula bye yakola akkiriza nti byali bituufu ate agamba biyinza okuba nga byaliwo olw'ensonga nti yali mwenyamivu wakati wa January n'Ogwokusatu nti teyagamba nti ennaku 2 z'Ogwokuna 2026 nti yali akyali mwenyamivu nti ate nti ekyokugamba nti omutwe gwe tegukola bulungi balina okuleeta obujulizi wabula si kugamba bugambi nti ayinza okuba nga omutwe gwe gwali tegukola bulungi nti oludda olw'omuwaabirwa be balina okuleeta obujulizi okukakasa kooti nti akaseera ako ke yakolerako ebintu ebyo nti omutwe gwe gwali tegukola bulungi nti ate waliwo omusango gwe bawadde ow'ekitiibwa Gwajjumba Joshua nti kugamba nti omuntu omutwe gwali tegukola bulungi balina okugendera ku bintu 3. Ekisooka okulaba nti omuntu omutwe gwe gwali tegukola bulungi ekiseera kye yakolerako omusango ogwo. Ekyokubiri balina okulaba nti okubeera nti omutwe gwali tegukola bulungi kye kyamuviirako okukola kye yakola. Era ekyokusatu balina okulaga nti akaseera ako yali tasobola kutegeera nti ekintu kye yali akola kyali si kirungi.
Again, my lord, this particular defense was established in the case of R versus Magnaton, which we provide on page 12. And in summary, my lord, the principles set out in the Magnaton case just to re-echo the 3-way test, my lord, that I have already highlighted in the Philippines case. Now, our submission, my lord, is that the defense has failed in proving any of the laid down principles in the Magnatan rule. And we just want, my Lord, to highlight the first of their failure is their lack of evidence to prove existence of a disease of mind. My Lord, what amounts to a disease of mind? Was defined in the case of R versus Sullivan, whose citation we provide on page 12. And my Lord, on page 13, we draw your attention to the second holding. My Lord, the first holding is equally important, but I just want to highlight the second holding, where the court held that when a man is guilty of a great offense, it must be very plain and clear. Before a man is allowed an exemption, my Lord, on the exemption on the basis of insanity. The court emphasized that that it is not every kind of frantic humor or something unacceptable in a man's actions, or that points him out to be such a madman as to be exempted from punishment. It must be a man that is totally deprived of his understanding and memory. A man, my Lord, that does not know what he is doing, no more than an infant. My Lord, by our nature as humans, nobody has a perfect mind. But for one to claim imperfection of mind as a defense, you must establish that your imperfection is such that you were incapable of appreciating anything, just like you see a baby. My Lord, in our case, the allegations of insanity are simply vague oral references to an alleged distress between January and March, the supposed effect likely to have been caused by the sickle cell disease, and my Lord, the allegations made in this court are the same blanket allegations that were made to PW11. On the police form 24. And my Lord, PW11 was clear that he could not confirm those allegations for want of the medical history of the accused. But in his examination, my lord, 7 days after the offense, 5
days?
5 days, my lord, 5 days after the offense, where that the accused was, in a nutshell, a person of proper mental understanding. My lord, we invite you to consider the evidence of this particular witness in as far as his professional findings were concerned. Opposed to the notes of allegations by the accused. But besides PW1's evidence, we also have evidence of PW12, rather PW11 is evidence. We have evidence of PW12 that had previously examined the accused on private basis, my lord. Just 3 months, my lord, before the offense, he still found him to be clear-minded. But also, my lord, court should consider the evidence from PW15. PW15, especially to the effect that the accused knew that he had killed 4 children. He knew he had killed human beings. My lord, the defense contends that this particular section, this particular fact was not included in the statement of PW15. But my lord, it is trite that not everything that police does or sees can practically be deduced in detail in a statement. The position of the law in Uganda versus Augustine Musana and 2 others. My lord, this case is reported in 1985 HCB. It's not in the bundle, my lord. A
copy to us?
Yes, my lord, we could. I just came up with, because I have to answer to the allegations that came out in, we could not. But my lord, we undertake to provide a copy.
Please give us the citation.
My lord, it's 1985 HCB.
The full citation.
Uganda versus Augustine Musana and 2 others. 1985 HCB. Page 20. My lord, at page 12 of the judgment, His Lordship Kalokora held that what a witness states in court is what the court should accept, because it is stated under oath, and the defense has an opportunity to cross-examine and has an opportunity of cross-examining the witness on it. But what a witness says at police is neither stated on oath nor is the witness cross-examined thereon by the defense. So clearly, my lord, absence of a police statement or a fact in a police statement can never be used to override the testimony of a witness on oath before court. So, my lord, besides the defense failing to prove existence of a disease of mind, we submit that they have also failed to prove that the accused lacked the requisite knowledge of the nature and quality of his acts. My lord, as to the nature and quality of acts, of the act, on page 15, we provide the case of Rex versus C.W. Rose, which emphasizes the principle that in a trial for murder where the defense of insanity is raised, the court must presume the prisoner to be sane and possessed of sufficient reason to be conscious of his crime unless he establishes the contrary and proves that he was suffering from such a disease of mind as to be unconscious of the nature and quality of his act. Or if so conscious, my lord, not to be conscious of the difference between right and wrong. My lord, in this case, without further emphasis, the revelations of the accused to PW 15 cannot be one of a person that did not understand the nature of his actions. My lord, we invite you to make reference to the detailed reasoning in our submissions. But the third failure, my lord, of the defense on their part is the failure to prove lack of knowledge of wrongfulness. The defense has the burden, my lord, to prove that their client, the accused, did not know that his actions were wrong. And my lord, wrong in law means legally wrong, not morally wrong. It's a legal test, my lord. So if the accused knows that his actions are against the law, then the defense of insanity, my lord, fails. Even if they had a mental sickness. We invite your lordship to consider the legal extent of what that standard means as brought out in the case of R versus Window on page 16. My lord, in this case, the husband overdosed the wife and caused the death, and after the death, he called the police and told the police that I believe I will be hanged for what I have done. And at trial, my lord, the court found that the accused's statement showed that he knew that his act was wrongful. Now, my lord, you are confronted with a similar fact where on the first interview of the accused by a person in authority, in the names of PW15, the accused discloses that he understands that what he had done can lead him to jail or even death. My lord, that is not an observation of a person who did not understand the consequences, that his actions were wrong. My lord, we have also addressed you on the possible...
Mr. Mwaganya, your 1 year, you've already finished it, and
okay.
How much more time do you still need?
My lord, now I will simply invite your lordship to make reference to the rest of our submissions as highlighted, my lord. But my lord, just allow me 10 to 15 minutes to make direct responses to what the defense submitted.
Just make a summary of...
Most obliged.
Nti oludda lw'omuwaabi lwalulemereddwa okuleeta obujulizi nti yali alina obulwadde bw'obwongo, nti kubanga bw'agamba nti yali alina obulwadde bw'obwongo okulaga nti mu butuufu yali tamanyi kyakola, yali yeeyisa ng'omwana omuto, nti buli muntu omutwe gwe teguteredde, naye omuntu bw'avaayo n'agamba nti omutwe gwe tegukola bulungi, alina okuba nga tategeera ddala kyakola. Okugamba nti omutwe gwe gwali tegukola tekimala, okugamba nti yali mwenyamivu wakati wa January n'omwezi ogwokusatu, nti ate ebyo byaviira kubeera n'obulwadde bwa nalubiri oba sickle cells, nti bwe baamukwata n'agamba omujulizi ow'okumi nga yamukebera n'amugamba bye yamugamba, naye teyabikkiriza olw'ensonga nti omusawo omulala yali tabikebedde okukakasa nti byali bituufu. nti era bamukebera oluvannyuma lw'ennaku 5 nga bino bituuseewo era ne basanga nti omutwe gwe gwali gukola bulungi. Nti okuggyako omujulizi ow'okumin'omu waliwo omujulizi ow'okuminababiri nti era yabukeberako mabega nga omwami Okere yali yeetutteyo mu ddwaliro nti emyezi 3 kino kiryoke kibeewo n'asanga ng'omutwe gwe gwali gukola bulungi nti era n'agamba Oweekitiibwa Omulamuzi nti atunuulire obujulizi bw'omujulizi w'okuminabataano kubanga yamugamba nti yali amanya ensonga lwaki yatta abaana. Oludda olw'omuwaabi lwalugamba nti yali takoze statement naye oludda oluwaabi lugamba nti omuntu ne bw'aba talina statement kasita ajja mu kooti n'awa obujulizi ng'alayidde kooti bw'erina okutwala nti balemereddwa okulaga nti yali tategeera kiki kye yali akola oba kyali kizitowa kitya. Era ne byayogera ng'agamba omujulizi wa 15 ng'amugamba ne byayogera ng'agamba omujulizi wa 15 kyali kiraga nti yali ategeera biki bye yali akoze nti olw'ensonga nti tebasobola okuleeta obujulizi okulaga nti bye yakola byali bikyamu nti yali amanyi bye yali akola kubanga bwe baamubuuza nga bamaze okumukwata yagamba nti yali amanyi nti ebintu bye yali akoze byali bisobola okumutwala mu kkomera oba okumuviirako okufa ekitegeeza yali amanyi biki bye yali akola nti byali bikyamu.
Yes, Mr. Morgan, you can proceed.
My Lord, very fast, in our response to the allegations of insanity as brought out by Counsel Kumbuga, my Lord, the claims of insanity as submitted, my Lord, are not borne out of evidence. They are allegations being made by counsel at the stage of submissions. For lack of a better word, my Lord, and with the greatest respect, it is evidence from the bar. My Lord, as to the allegations that the accused was such that was mad to the extent, my Lord, if we understood him, the extent of living on the streets, that there was evidence that accused was living on the street, and that this is attributed to his mental inabilities. My Lord, again, this is not evidence from the accused. He did not qualify the reasons for his going on the street as being mental illness. To the contrary, my Lord, the evidence from DW3, 3, demonstrates the accused as a philanthropist, gathering and providing for street children. There is no evidence to show, my Lord, that he was on the street, that he went on the street where he found DW3 as a person of mental incapacity. In fact, my Lord, evidence of DW3 is that the accused was actually paying and sponsoring the welfare of street children. I do not think, my Lord, that a person with mental instability can carry out such acts of philanthropy. My Lord, the defense has submitted that because the accused was got with some painkillers, that is evidence of mental illness. My Lord, painkillers are drugs in common usage. In fact, the accused did not tell this court what he was doing with those painkillers. It is, in our opinion, my Lord, improper to conclude that whoever carries or uses painkillers is a person with mental illness. My Lord, as to the references to PW11, PW11 is evidence that even people with mental illness can transact etc. My Lord, the witness was clear that they can only do such normal businesses during the time when they are normal. Indeed, my Lord, you can see that just minutes prior to the killing of the children, just within minutes, the accused, from the exhibits on record, my Lord, was downloading money from his bank account to his phone and transacting in mobile money from his phone to the phone of the caretaker. That can only be done by a person who is normal. My Lord, on the aspect of the alleged episodes between No, my Lord, not episodes. My Lord, not episodes. As to the assertion, my Lord, that that prosecution did not bring any evidence to show that between the 1st and the 7th of April, the accused was normal. We have already highlighted, my Lord, that that burden rests on the defense and not the other way around. My Lord, there is no evidence that the accused was denied the citizenship of Uganda at all, or if so, that denial was on account of mental illness. My Lord, The allegation is that because the accused is said to have made some laughters during the proceedings, these proceedings, and therefore that is evidence of mental illness. My Lord, there is no such standard. That laughing alone is a standard to determine a person's mental capacity. The accused was not asked why he was laughing. It cannot be assumed. My Lord, I've already addressed the note on Police Form 3. I'm Police Form 24. My Lord, the criticism that or against PW made against PW 15 that he concealed information of the accused is accused having been in Butabika mental hospital. And that this unrevealed information by prosecution should be used as evidence of to prove mental illness, my Lord. My Lord, that is not the legal requirement. What we have on record is that the witness was asked and he says he is aware of that information. And my Lord, the information was abundant on record in Police Form 24. This witness was never asked by the defense, my Lord, whether he verified that information. Because this was information from the accused. My Lord, the defense made a case for what they termed criminal negligence, the absence of a guard at the center, absence of a visitor's book, my Lord, this court is trying murder. It is not the school management on trial. It is the person that took advantage of the circumstances to commit the crimes that is on trial. In any case, my Lord, the absence of a permanent guard or a visitor's book can never be a defense to murder. Yes. To the contrary, my Lord, a person who commits murder A person who commits murder due to absence of security or other preventive measures can only be said to have done so consciously. My Lord, that a witness called Mpamizo did investigations and produced exhibits in the middle of the trial. We respond that, my Lord, all exhibits of Mr. Mpamizo were disclosed to the defense. The defense never objected to his testimony. They even never expressed their inability to deal with that evidence for whatever reason. They properly cross-examined the witness. And so, my Lord, the late service of Mr. Mpamizo's evidence never occasioned any miscarriage of justice. My Lord, as for Mr. Angulo, prosecution witness number 18, in regard to the court order my Lord, we submit that the witness was clear that he was only concerned with the court order as opposed to the underlying processes. My Lord, we draw your attention to the loan affidavits Section 4 of the Commissioner for Oath Act allows any magistrate, by virtue of their official powers, to commission oaths. In fact, it talks about magistrates, registrars, etc. My Lord, there is no law that invalidates an affidavit that is commissioned by a magistrate who proceeds to hear the same matter. My Lord, that conflict only arises in respect of counsel, advocates, not judicial officers. And my Lord, that is the position in Section 5 of the Commissioner for Oath Act, which restricts that type of conflict to advocates and not magistrates. In fact, my Lord, to fault a magistrate who commissions an affidavit in an application before themselves, my Lord, would be also to fault the powers of this court that administers oath, of the witness, and proceeds to hear the same witness in evidence. The courts are not restricted in law. My Lord, the absence of a court seal on a court document does not in any way invalidate the force of law in that document. My Lord, reference is made to section 221 of the MCA, which speaks to that effect. Absence of a seal doesn't affect the validity of a court order. There is a presumption that every court order, my Lord, is authentic, enforceable, and legal, unless it is overturned. Now, on the issue, my Lord, just rushing through. My Lord, on the issue of PW7, of the recording office of PW7 not signing the plain the witness statement of the witness, my Lord, I pray that you still make reference to the principle in Uganda versus Augustine Musana, cited. My Lord, on the submissions on the case of Kantinti, Uganda versus Kantinti, we understood the defense to say that because court found Kantinti insane in that matter, for the reasons they state, and it should apply here. My Lord, in Kantinti, the facts in Kantinti are distinguishable with the present case before you. In Kantinti, the accused person produced cogent evidence of his mental illness, including medical evidence, including photographs of his state before the commission of the offense. And so the court rightly found him so. My Lord, that is not the case in this case. We have been criticized, my Lord, for not having called Semanda, because Semanda is the investigating officer. My Lord, there are three things. One, a criminal case like this, my Lord, is not investigated by a sole investigating officer. In this case, my Lord, prosecution produced PW 14 and 15, who are all technically investigating officers in this matter. My Lord, the police form 17s were all tendered and admitted in evidence. My Lord, once an exhibit is admitted, Section 133 of the Evidence Act does not put a limit as to which number of witnesses should be called to prove a fact in issue. Secondly, the decision, my Lord, in the case of Alfred Bumbo, my Lord, B-O-M-B-O, and 3 others versus Uganda. My Lord, this is a Supreme Court Criminal Appeal number 28 of 1994. It's available on ULI. The Supreme Court, my Lord, in this case held that whereas it is desirable that evidence of the investigating officer and or a re-arresting officer should always be given where necessary, we think that where other evidence is available and proves the prosecution's case to the required standard, the absence of such evidence would not, as a rule, be fatal to the conviction of an accused person. My Lord, the Supreme Court went on to say that it depends on the circumstances of each case. So the defense, my Lord, cannot be right to criticize the prosecution for not having called every other possible witness in the matter. My Lord, finally, on the issue, my Lord, that the police form 17s, police form 17s and other exhibits which should have been spoken about by Semanda, who was not called, just redundant on record or something like that. My Lord, the law has always been clear. My Lord, we shall provide this authority. It's a case of Johnny, as in John Y, John, then Y, Johnny versus James. Is 2006 in bracket 3 KLT 368. My Lord, this is a persuasive authority from the High Court of India, but it's of great relevance, my Lord, in addressing this issue. That court, my Lord, held that when the court receives a document and assigns, when a court receives documents, it's a plural, documents, and assigns numbers to them, it must clearly be assumed, that the documents have been admitted or at least admitted subject to objections which are raised. That as soon as the court assigns a number, and records the same in the disposition, it must be held that the subsequent procedural requirements, such as fixing of the seal, endorsement, has been performed. My Lord, in this case, I'm even adding, calling additional witnesses to prove that, have been performed. Has not been performed, that because those procedural requirements have not been performed, cannot lead the court to a conclusion that the document has not been admitted. My Lord, the court concluded by saying that endorsements and fixing of seals are post-admission formalities and are of no consequence or avail. So in our case, my Lord, once exhibits are admitted, they are not objected to. We can't, a party cannot turn around to say that they are of no value on record because they have been properly so admitted. My Lord, we are so grateful for your time and attention. We invite you to consider other points that we have not highlighted but are included in our written summary to find that we have not just proved all the 4 ingredients, but that the accused's defense of insanity is unavailable, because the accused has not discharged the legal burden on him. And my Lord, to finally proceed and find the accused guilty of all the 4 counts of murder as indicted. We so pray, Your Lordship.
Thank you very much. Summarize that, please.
Omujulizi ow'okubiri yajja n'agamba nti omuntu alina obulwadde bw'obwongo aba asobola kukola ebintu ebya bulijjo mu kaseera k'abeerera nga atereddemu. N'agamba nti bagamba nti nga nti oludda olwaabi terwaleeta bujulizi okulaga nti wakati wa nga 1-7 ogw'Okuna-2026 nti omuwaabirwa yali bulungi, obwongo bwe bwali bukola bulungi, nti naye bagamba nti omutwe gwali tegukola bulungi n'olwekyo balina okuleeta obujulizi, era ne bagamba nti tewaali bujulizi obulaga nti baali baganya okumuwa obutuuze bwa Uganda, nti oba baagana okubumuwa olw'ensonga nti yali alina obulwadde bw'obwongo. N'abagamba nti oludda lw'omuwaabirwa lugamba nti abadde ng'asekaaseka nga kooti etudde, naye bo bagamba nti ekyo tekiraga nti omuntu omutwe gwe tegukola bulungi. Era bagambye nti omujulizi wa 15 nti waliwo obujulizi bwe yakweka ng'okugamba nti omuwaabirwa yali kwebutabika, naye ekyo tebasobola kukikozesa kukakasa nti yali alina obulwadde bw'obwongo kubanga tewali obukakafu obulaga ekyo. ne bagamba nti ku ssomero nti waali tewali musirikale oba ekitabo kye bawandiikamu, era n'agamba nti kooti eno eri kuwuliriza musango gw'obutemu so si kuwuliriza eby'essomero, nti omuntu eyakozesa omukisa ogwo okulaba nti waali tewali mukuumi n'agenda n'atta abaana, kitegeeza nti yali amanyi biki bye yali akola. Ne boogera ne ku pain killers ze bamusanga nazo, ne bagamba nti pain killers yeddagala oba makerenda abantu ge bakozesa mu bulijjo, n'olwekyo tekisobola kulaga nti yali alina makerenda olw'ensonga nti yali alina obulwadde bw'obwongo.
Okay, do you have a right of rejoinder? Okay, you can rejoin. How much time do you need?
My Lord, 3 to 5 minutes I will be through.
Okay, please proceed.
My Lord, I invite this Honorable Court to look at page 331 and 310.
331?
310, 331, 315. My Lord, in an attempt to call the medical personnel from Butavika to come to court and clarify the issue of insanity, I made an application to this Honorable Court. In this application, Prosecution objected. In this application, this Honorable Court overruled. On page 331, during the testimony of DW2, court stated that, as earlier on said, I would make a decision as to whether it is necessary to summon anyone from Butavika after hearing the evidence of DW2. I invite this court to hold that the submission of the land chief state attorney as regard to insanity are in contempt of this order because he never appealed against it. My Lord, I invite this Honorable Court to hold that the submission of the prosecution on the issue that defense failed to bring a medical doctor from Butavika to complete or to defend the defense of insanity is in contempt of the court order that is still existing. Therefore, the order makes the prosecution evidence incomplete. The defense evidence didn't also bring this witness. Now, the question is,
You seem to be losing me. I'm failing to get that argument.
Therefore, since there was a recommendation from a medical doctor on PF24 that prosecution must go.
No, that's not true, Mr. Kumi.
Okay, my Lord, let me quote how it is on PF24.
Okay, he said there should be an assessment, but he did not say that the prosecution must do that.
My Lord, let me go to PF20 fund, I quote the way it is. My Lord, this was...
Mr. Kumbuga, we have...
Yes, my Lord.
No,
But
what I'm trying to tell you
Yes,
is that
my Lord.
that form has actually been referred to a number of times.
Yes, my Lord.
And we have all the information there on.
My Lord,
And you actually...
I would bring this analogy to court. I'm a candidate in an examination room. This court is an examiner to give marks. My work is to bring to the attention of this court and the examiner to mark the script. Allow me, my Lord, read out this page.
Please go ahead.
Much obliged. My Lord, this is the finding of this doctor. Further, mental assessment is necessary since the medical documents were since no medical documents were availed and he was the only source of this information. Therefore, it is the prosecution that failed in its burden of proving the case beyond reasonable doubt. My Lord, the case he has quoted, John versus James, is idle record. It is a civil authority, not a criminal authority. This honorable court should not rely on it while coming up in a fair judgment.
On exhibit, and let's proceed.
And therefore, my Lord, as you come to judgment, as I said earlier on, consider our submissions in the final determination of this case.
Thank you very much to both sides. Could you please come here for just some consultations? All of you, please. Please come.
Kati bannamateeka bonna bagenza okusinkana omulamuzi kyetulowooza nti kati bagenda kwogera ku deeti ya judgment kubanga kati kyekisinga okuba nga kyekikulu era kyekirindiddwa bonna bamaze okuwaayo ensonga zaabwe ezitaasa oba ezitataasa muntu waabwe. So akakati kyetugenda maaso n'okulaba bagenda kuharmonizinga kati mbeera eddako kubanga kati olunaku tuyinza okuba tusigazizza oluluka lwebagenda okulangirira oba lwebanatutegeeza. So abwebityo bikyagenda kumwe abagenda maaso n'okutulaba state wamu ne defense bebuka kati abasinkana abogera n'omulamuzi okubaako bye battaanyaako ebitonotono ate tumanye butya ekintu bwe kinaaba kigenda okutambula. Katuwulire ebivuddeyo.
Okay, when we were starting this trial on the 13th, we appointed some 3 people who we said are called assessors, and they are appointed from members of the public. They are lay people who are supposed to give the case a layman's view. And now the law requires me to sum up for them the evidence that was adduced both by the prosecution and the defense for the accused person. And after that, they are expected to give me their opinion. And I said that their opinion does not bind the court. The court retains the powers to make a judgment. So right now, I'm going to sum up to the assessors. Ladies and gentlemen assessors, please pay attention to what I'm going to say, and I'll give you some time to give me your opinion. Okay, the accused person is indicted on 4 counts of murder, contrary to sections 171 and 172 of the Penal Code Act, chapter 128. In count 1, it is alleged that Christopher Okello Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Teku Gideon. In count 2, it is alleged that Christopher Okello Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Center, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Keisha Agenroth Otim. And in count 3, it is alleged that Christopher Okello Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Seryange Ignatius. And count 4, it is alleged that Christopher Okello Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Odeke Ryan. The burden and standard of proof, the burden to prove the allegations made against the accused person lies on the prosecution, and the standard of proof is beyond reasonable doubt. Under the Constitution, the accused person is presumed innocent until he pleads guilty or until he has been proved guilty by the prosecution. In this case, the accused person pleaded not guilty on all counts, thereby putting all the burden on the prosecution to prove his guilt beyond reasonable doubt. And this burden does not shift. Proof beyond reasonable doubt does not mean proof beyond any shadow of doubt. Yeah, and in a case of murder like this one, prosecution bears the burden to prove the following ingredients. Please pay attention. 1, that there was death of 4 people, namely Teku Gideon, who is in count 1, Keisha Agenroth Otim in count 2, Seryange Ignatius in count 3, and Odeke Ryan in count 4. That their deaths were unlawfully caused, and that whoever caused their death did so with malice aforethought. That is to say, he had the intention to kill, or the knowledge that the act would result into the deaths of these 4 children. And lastly, that the accused person caused or participated in the unlawful deaths. Proof of the ingredients. Death may be proved by post-mortem reports, the person or persons who saw the dead body, and those who attended the burial. In this case, in order to prove this ingredient, the prosecution adduced the evidence of Dr. Katongole Abdul, prosecution witness number 1, who performed the post-mortem examinations on the bodies of the 4 deceased children. That is Teku Gideon, Keisha Agenroth Otim, Seryange Ignatius, and Odeke Ryan, who confirmed that the 4 children were dead. The respective parents of the children, namely Apollo Stella, Marvin PW3, Mbazira Lawrence PW4, and Okrut Simon PW5, the parents also confirmed that the children were dead and buried. The evidence of the caretaker, Namtevi Phoebe, who is PW6, and the coordinator of the care center, Miss Annette Agoye Odongo, who is PW7, also testified to the death of the children. And the evidence of the district CID officer, Kabalagala, SRite James, PW15, and the evidence of the scenes of crimes officer, PW14, they all talked about seeing the dead bodies of the 4 children. One dead body was at the center, which they called the primary scene, and the 3 dead bodies were at Wensi Medical Center, and they called that the secondary scene. Unlawfulness of as an ingredient. All homicide cases are presumed to be unlawful unless accidental or authorized by law. And Namtevi Phoebe, Miss Aneta Goye, testified on how the attack on the children was done. The district CID Kabalagala and the Soko, scenes of crimes officer, described the primary scene of crime, which was Gaba at the Childhood Development Center, where the crime is alleged to have happened, and the secondary scene being Wensi. And the Soko, the scenes of crimes officer, took photographs of both scenes, including the photographs of the dead bodies, which you had an opportunity to look at in Exhibit PEX10. Malice aforethought. This is a state of mind which may not be proved using direct evidence, but circumstances surrounding the case. It may be inferred from the nature of injuries, the type of weapon used, the part of the body on which the injuries are inflicted, prior planning and prior threats, and the conduct of the accused person during, prior, and after the incident. In this case, the prosecution adduced the evidence of PW1, Dr. Katongole Abdul, who examined the 4 bodies of the deceased and described the injuries on all the bodies of the 4 children were on the necks. And he concluded that the cause of death for all the children was hypovolemic shock due to deep cut injuries to the neck, and the same were caused by sharp objects. Miss Namtebi Phoebe, PW6, and Miss Aneta Goyo Dongo, PW7, the eyewitnesses to the crime, saw and identified the weapon used as a knife. Namtebi Phoebe stated that she saw the accused throw the knife over the chain-linked fence. The knife was later recovered and was admitted as a prosecution exhibit. The other witnesses testifying to the injuries on the body of the deceased were the district CID, the division or CID officer Kabalagala SRite James, who is PW15, and the scenes of crime officer, who is PW14. In his report, you looked at that report. Malice aforethought may also be inferred from the evidence of prior planning. Prosecution adduced evidence of Namtebi Phoebe, PW6, regarding the visit of the accused person at Gaba Early Childhood Development Center, that's the primary scene, on the 1st of April 2026, that is a day prior to the date of the offense. And also evidence of PW18, who analyzed the phones of the accused persons and other electronic devices and established that the accused had previously used his phone to make Google searches for kindergartens, daycare centers, play centers, among others. Accused participation. This may be proved by direct or circumstantial evidence, or both direct and circumstantial evidence. Direct evidence is where there are eyewitnesses to the crime who state that they saw the accused person commit the crime. Circumstantial evidence, on the other hand, is evidence from the surrounding circumstances of the case. The circumstances must be such that they point to nothing else than the guilt of the accused person. Prosecution adduced the evidence of Phoebe Namtebi, PW6, and Aneta Goye Odong, PW7, who testified that they saw Okello or Onyum Christopher, the accused person, cutting the 4 children inside the premises of Gaba Early Childhood Development Center on the 2nd of April 2026 at about 11 a.m. or thereabout with a knife. SRite James, PW15, the divisional CID officer of Kabalagala, and the Soko, scenes of crimes officer, responded and found when the accused had been arrested within the premises by Cyrus and Moses, security guard who was at the church gate. The accused was detained in the guard house of Gaba Early Childhood Development Center to keep him away from the angry mob that had gathered. and they rearrested him. There was DNA evidence, also PW 17, which revealed that the DNA of the accused person was actually found on the hand of the knife, which was recovered behind the scene. And both the report and the knife were admitted. There was also the DNA evidence also found some of the DNA from the bodies of the children on the clothes of the accused person. I will talk about contradictions and inconsistencies. There may be contradictions and inconsistencies in prosecution evidence. There are those contradictions and inconsistencies which are minor, and those should be ignored. However, if they are grave contradictions and inconsistencies that go to the root of the matter, those ones will lead to the discrediting of the evidence, and it will not be relied on. I will now turn to the defense case. The defense of the accused person must be weighed against the prosecution's evidence. In this case, the accused gave an unsworn statement and called two witnesses in his defense, DW2 and DW3. The accused did not expressly deny causing the deaths of the 4 children, but he repeatedly stated that he did not do so intentionally or deliberately. Although his evidence was lengthy, it may be summarized as follows. He did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected that could have contributed to the death of their children. He said he was not mentally okay. He also denied being forward-minded in the killing of the children. In respect to this, he made reference to the book about the war, which was part of the evidence of PW18, who analyzed his flash disk and found that he had saved a book entitled Sun Tzu on the Art of War. He said that that book or file was saved long ago, and it cannot be said to apply to the killing of the children. He also denied being deliberate and with forethought while making reference to the evidence of the searches he made using his phone, as testified by PW18, and specifically the search for ISIS beheading and for schools that teach young children. He said that whereas these searches suggest that he did it deliberately, but other factors were forcing him to make those searches. He further stated that he was under the control of some people whom he said were in 3 categories. And the accused person further stated that between January to March, he entered into an especially distressing period because he was contending with some people who were surveilling him, made many demands from him, and they threatened to kill him. They began demanding for money, and he notes that they had all the capabilities, and they were following him closely. As a result, he left the neighborhood of Bunga, where he was staying, and started sleeping on the streets. He stated that as a result of this, he tried to end it some way and somehow, and tried a few things to bring the whole thing to an end. He tried to flee the country, he tried to rob a bank, and also tried to kill his brother's family. He then said those people whom he at times referred to as his friends during his testimony had to do with his actions of the second. He stated that court should not honor the charges for murder because there were some circumstances that forced him to act the way he did on second, that is the day of the incident. The accused also kept on denying the claim that he caused the deaths of the 4 children for human sacrifice, and insisted many times that he was coerced to make those statements. However, you will recall that the plain and the charge and caution statements were never brought as prosecution evidence. You will also realize that some of his statements would have required some more explanation from him, but because he gave an unsworn statement, he had to give his story uninterrupted and without assistance from his lawyers. From the above evidence of the accused person and from some of the questions during cross-examination of some of the prosecution witnesses, the accused seems to raise a defense of insanity and or diminished responsibility. The law presumes sanity under Section 10 of the Penal Code Act. It provides that, and I quote, every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved. Earlier on, you heard the prosecutor saying this. Every person, all of us here are presumed to be sane until the contrary is proved. Section 11 of the Penal Code Act provides that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind, incapable of understanding what he or she is doing, or of knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. And diminished responsibility is defined in section 177 and subsection 1 of the Penal Code Act, which provides that where a person is found guilty of murder or being a party to the murder of another, and the court is satisfied that the person was suffering from such abnormality of the mind, whether arising from a condition of arrested or retarded development of mind, or any inherent causes or induced by disease or injury, has substantially impaired his or her mental responsibility for his or her acts and omissions in doing or being party to the murder, the court shall make a special finding to the effect that the accused person was guilty of murder, but with diminished responsibility. Subsection 2 thereof provides that on a charge of murder, it shall be for the defense to prove that the person charged was suffering from an abnormality of mind, as is mentioned in subsection 1. You will also be expected to review the evidence regarding the lifestyle, the conduct, and or behavior of the accused person before the incident on April 2nd, 2026. This evidence can be found in the testimonies of his two landlords, one in Bunga, that is PW9, and another in Chanja, PW10. It can also be found in the testimony of PW8, the car rental, the person who gave him or hired to him the car. The vehicle, you looked at the vehicle, you know the registration number. The officer who analyzed the CCTV footage, PW18 who analyzed the accused person's electronic gadgets, Ms. Namteli Phoebe, PW6 who interacted with the accused on the 1st and then on the 2nd of April. Also Ms. Annette Odong who interacted with the accused person very closely a few minutes before the attack. You may also consider for your guidance evidence doctors, Dr. Roger Agenda of CCare IHK Kampala, who made a psychiatric and mental examination of the accused person on the 30th of December 2025 at the request of the accused person. And then evidence of Dr. Emmanuel Nwamanya, PW11, who is a police surgeon, but at the same time a psychiatrist, who did a mental examination of the accused on the 7th of April, 2026. Ladies and gentlemen assessors, you had the opportunity to listen to all the prosecution witnesses. You also listened to the defense evidence. You should be able to form your opinion in light of the legal principles that I have explained above, and advise the court on whether you believe that the prosecution's evidence adduced has proved the case against the accused person beyond reasonable doubt in light of the defense that he has raised. If you find that the prosecution has proved its case against the accused person beyond reasonable doubt on all counts, you will advise me to find the accused person guilty of the offense of murder on all counts, and you will advise me to convict him as indicted. If, in your opinion, the prosecution has proved some counts and failed to prove others, you will advise me to convict on those proved and acquit on those unproved. However, if you find that from the evidence of the prosecution, analyzed with the defense evidence, there is reasonable doubt, that doubt should be resolved in favor of the accused person. If, in your opinion, the accused person was insane or of unsound mind at the time he caused the death of the 4 children, you will advise me to acquit him because insanity is a total defense. But yes, that is it. And I want to hear from you. How much time do you need to give me your opinion?
You will check today? This evening?
How much time do you need?
10 minutes, my lord.
That will determine whether we are doing it today or we are doing it tomorrow or another day.
10 minutes, my lord.
10 minutes are enough?
Yes, my lord.
Okay, so we are breaking off for 10 minutes and we shall come back to hear from the assessors.
Tugenda omulamu eddakiika 10 tukomewo tuwulirize baaseesa.
Hello? 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 Naye nga tunaakomawo okuwulira baaseesa.
Let me hear from your sisters. Please, the first one. Remind me of your name, please.
My name is Ainomugisha Resha.
You also confirm a joint opinion.
Yes, my lord.
The third lady.
Shawija Maria Topista, my lord, and I do confirm that we are giving our joint opinion.
Who is giving the opinion?
It's my lord.
Please go ahead.
My lord, the accused person is charged with 4 counts of murder. Below are the ingredients to be proved beyond reasonable doubt by
Okay, we are writing, Mr. Musana.
Oh, sorry, my lord.
Below are the ingredients
To be proved beyond reasonable doubt by the prosecution, my lord.
Please proceed.
My lord, we have murder as ingredient number 1.
Murder or death?
Death, sorry, my lord. That the death was unlawful. Malice aforethought and participation. My lord, on ingredients 1, 2, and 3, we relied on the evidence PW1, Dr. Katongole Abudu, who examined the 4 deceased juveniles in his postmortem reports, which were attended in this honorable court as PE1, PX1, PX2, PX3, and PEX4 respectively. He confirmed to this honorable court that he examined the bodies of Etek Gideon, whose cause of death was a deep cut injury on the neck, again wrote Keisha Otim, whose cause of death was hypervolemic shock following a deep cut wound on the neck.
Can you repeat that, please?
Again wrote Keisha Otim, whose cause of death was hypervolemic shock following a deep cut wound on the neck. Young Mange Ignatius, whose cause of death was a deep cut injury on the neck. And Odeke Ryan, who died of hypovolemic shock following deep cut injuries on the right side of the neck. My lord, this evidence was collaborated with that of PW2, PW3, PW2, PW3, PW4, PW5, PW6, PW7, PW11, and PW14.
PW2, PW4, 3, 4,
5, 6, 7, 11, and 14. We are therefore convinced that the prosecution has laid overwhelming evidence, which is of course reasonable doubt, on the first three ingredients of murder.
Okay, so let me get that. The prosecution has laid overwhelming evidence,
which is beyond reasonable doubt on the first three ingredients of murder. As pertains participation, ingredient 4, we relied on the evidence of PW6, PW7, PW11, and PW15.
PW6,
7, 11, and 15, my lord.
okay.
My lord collaborated with that of PW13, AIP Odong Emmanuel, who authored the CCTV analysis report. Which was subsequently tendered in this honorable court and marked PEX9A.
Let's proceed.
We concentrated on the images of the accused person captured on 2nd April 2026 on the CCTV analysis report. The images are on pages 50 and 51. Furthermore, the flash disk of CCTV footages marked as PEX9B contains a video of the accused person captured on the day prior to the incidents parking at Renewal Circle, which is close to the scene of crime. My lord, this prompted us to believe that this heinous act was premeditated. The evidence of PW17 also implicates the accused person, most especially in his forensic report which was tendered in this honorable court and and marked as PEX 16. He concluded on pages 19 of 28 of the report, paragraph 18.
You concluded on which page?
On pages 19 of 28 of the report, paragraph 18. Putting the accused person at the scene of crime by virtue of the DNA examinations made on his sunglasses, shirt, black trouser, knife, vis-a-vis the DNA examinations he made on the bodies and clothes of the four deceased juveniles. With the above, we are convinced that the prosecution has also proved the fourth ingredient beyond reasonable doubt. In his defense, my lord, the accused person said that he didn't intentionally cause the death of the four children. And that he was coerced to accept the charges. Furthermore, he requested this honorable court not to honor the prosecution prayer to convict him on the four charges of murder, because he contends that there are circumstances that forced him to act the way he acted on the 2nd day of April 2026. However, my lord, he didn't present any evidence to support his claim. Whereas in the evidence...
Okay, that's slow. He was forced to act in the way he did on the 2nd of April 2026.
However, he didn't present any evidence to support his claim. Whereas in the evidence of PW11 Dr. Nwamanya, who examined the accused person on police form 24, which was tendered in this honorable court as PEX 7, he was absolutely clear that basing on his psychiatric
PF 24 exhibit PEX 7
was absolutely clear that basing on his psychiatric interview and personal mental state examination,
basing on his
psychiatric interview and personal mental examination at the time the accused was presented to him, he established that Mr. Onyum Christopher Okello had no established mental disorder. This collaborates with the evidence of Dr. Rogers agenda. In his sanity assessment report, which was admitted on court record as PEX 8A, we are therefore convinced that the accused person is mentally stable, as opposed to the evidence in defense. My Lord, the accused person presented the other two defense witnesses, but according to us, their evidence was not concrete enough to water down the prosecution evidence.
Their evidence
was concrete enough to water down the prosecution evidence, my Lord. My Lord, in conclusion, we are convinced that the prosecution has proved all ingredients in the 4 counts beyond reasonable doubt.
Prosecution
has proved all ingredients in the 4 counts beyond reasonable doubt. We therefore advise this honorable court to convict the accused person in the 4 counts as charged. That's our humble opinion, Your Lordship.
Mr. Inomugisha, is this your opinion as well?
Yes, my Lord.
Ms. Cholija Maria, is that your opinion?
Yes, my Lord.
Thank you very, very much for being attentive. Let's have the interpretation, please.
Atutandika omusango guno, kooti yafuna abantu 3 nga ba bulijjo tebaasoma amateeka okujja kuwuliriza obujulizi oluvannyuma bawabule kooti, era bazze kuwa kooti ne bagamba nti bonna endowooza yaabwe eri emu oba efaanana. Ne bagamba nti mu misango gino gyonna balina okugoberera ebintu 4. Ekisooka, balina okulaba nti waliwo abaana 4 abaafa, ng'ate okufa kwabwe kwali mu bumenyi bw'amateeka, nti ate eyabatta yali alina ekigendererwa eky'okubatta, ate balina okulaga nti omuvunaanibwa ye yazza omusango guno. Bonna awamu balowoozeza nti oludda oluwaali luleese obujulizi obumala okulaga ebyo bina bye tuva kusoma, era ne bagamba nti omuwaabirwa omutwe gwe gwali gukola bulungi oba yali talina bulwadde bwa bwongo. N'olwekyo bawawudde kooti nti esange nga emisango ena gyonna nga gimusinga.
Mr. Okello, the assessors, 3 assessors have advised me to convict you. They have said that from their assessment, the prosecution has proved all the 4 counts against you beyond reasonable doubt. But like I told you from the beginning, their opinion does not bind the court. The court reserves the right and the power to make the final verdict. So I adjourn this case to Thursday 30th at 10 a.m. for judgment. The accused person is further remanded till then.
Musango guno gwogezeddwayo tuusa ku Lwokuna kkooti ow'ensala yaayo ku musango guno.
Tuli ku Salty TV. Tweyanziza nnyo tweyanzeege abalabi aba Salty TV. Bwe tutyo bwe tutambudde olunaku olwaleero
Kituufu omulamuzi ayogedde bulungi nnyo nabasazza kimugamba omusango obuna yagusala omusajja ndi mulaluuti yali mutafu wa bwongo era abatuuze tusabise nnyo omulamuzi kyatugambye n'okulukuna bawe ensala y'omusango kubanga omusajja abaana yabatta ng'alina kigendererwa era bafundise bati bagamba kati komwe okulukuna tufuna obuki obwenkanya
owuli otya sofa mulinako we mutuuse oba tulinako tuuse n'omusango guno mwe mubadde TV badde wanga mulaba
Sensokera ddala okweyanza abalabi ba Salty TV n'omwami ono mwebale kubanga muyangembe sofa kinira omusango gutambula tuli basanyufu nnyo olw'okusalawo kw'omulamuzi kubanga tubadde tusuubira nti leero musango ejja kuba nnungi eriffe ate naffe obwenkanya bunaatuweebwa mwebale ddala
otya
abazi mwala Kamanzi nensaba kimu Museveni ave yazaala yata abaana baffe lwajira bamusajja
bakugambye basala ku lwako nakyenkukuziza obuliro otya wama
ze mu ndowooza yange oba n'empulira yange mazima era kyemmanyi bagenda kugusala nga gwa mazima na bwenkanya naye ng'omusajja oyo yeetaga kufa bantu bano tetulina beera nabo mu society
kufa bufi teri kirala tetwagala gavumenti egambe emyaka tetwagala omusajja tasaana nakuba mmere mu bantu kufa bufi kufa tetwagala kufa bufi ono omusajja tasaana kusiba myaka oba myaka emeka tebatugamba ffe kyetwagala ffe kufa kuba abaana be yatta baali bato tebabbangako kufa bufi
papa kino kitiibwa kya mukama okuva ewa state ne judge kye bakoze ku lw'omusaayi gw'abaana baffe Okello gwe yayiwa bwe tutuuse tulabawo
tweyanzege abalabi baffe aba Salty TV okuviira ddala gye twatandikira paka we tutuuse kati alugenda kubeera lunaku lwakuna lwe bagenda okubanga ate bamaliriza ensonga zino nze okwange kubeera kwebaza neebaza nnyo ttiimu bwe tukoze Yasini Kikoyo twakolako ne Eddie Nsubuga tubadde ne Isaac Kyagambire baddwa ate nga mu buufu obwo nebaza omusumba Alozias Bugingo MD olw'okubanga obudde bwonna abuwaddeyo ku lw'omusango guno okuva ku makya paka omusango lwe guggwa ate ne nebaza mukama wange Solomon Ato olw'okubanga akoze enteekateeka zonna erudde eri okubanga ebintu bino bitambula bulungi. Oyo mwebalizaako Kalebu Akandanaho ne mwebalizaako Kenneth Kikomaga ne mwebalizaako Favor wamu ne Fred Ekigozi nti mwebale nnyo mwebalire ddala byonna tubasiibulidde wano tulabagane tuddingane ku lunaku olwokuna.